This is Bloomberg Law with June Grasso from Bloomberg Radio.
About 1.6 million school children currently use e-cigarettes. Flavored vapes with colorful names that evoke candy and sweets are particularly appealing to young people, which has prompted the Food and Drug Administration to curb access to the products. The FDA turned down two companies' applications to market e-cigarettes with names like Jimmy the Juice Man Peachy Strawberry and Suicide Bunny Mother's Milk and Cookies. The agency's attorney, Curtis Gannon, defended its position at the Supreme Court.
Research has long shown that flavors increased youth appeal of tobacco products, and evidence accumulates further confirming that youth are particularly attracted to flavored ends products. The concern would be that they're getting addicted to tobacco at a time to nicotine, at a time when nicotine is dangerous to their developing brains and may be, sentencing them to a long life of needing to satisfy that addiction.
The vaping companies say the FDA changed its standards with little warning as it blocked the sale of more than 1 million new flavored products. But Justice Elena Kagan said that the FDA's position has been clear.
You know that FDA thinks that flavors, FDA has been completely upfront about this, and I think that the point, that flavors, you give people blueberry vapes, the difficulty with that, and FDA I think has tried to document this, is that blueberry vapes are very appealing to 16-year-olds, not to 40-year-olds.
Aside from legalities, the practical question is, what's the remedy, even if the court rules for the vaping companies? Because as Justice Brett Kavanaugh pointed out to the company's attorney, Eric Heyer, the companies can always reapply to the FDA for sales authorization.
And if they won this case, they can reapply.
If they won this case or if they lose this case, they will be able to reapply.
That's my question about what the relief really accomplishes here that is being sought as a practical matter. I understand the legal point. The FDA acted arbitrarily and capriciously, but either way, it's going to be that they can reapply and hope to succeed, right?
This case is an appeal from the conservative Fifth Circuit's decision finding that the agency unfairly shifted its standards for approving the vaping products while deciding on applications from the two companies. Joining me is Shawn Collins, a partner at Strading Yocca Carlson Rauth. Give us some background on the FDA and these flavored e-cigarettes.
Let's start with what the FDA's mandate is. The FDA's mandate is to look out for the health and well-being of the general American public, meaning they are supposed to certify all foods and drugs and certify that they are healthy and beneficial for the well-being of the citizens of the United States of America. And so what we have going on between the FDA and the e-cigarette companies right now, I call it a bit of a game of whack-a-mole. And so it's like anything, if you regulate one product and you're successful in getting a certain product regulated, another product's going to pop up. And so, the FDA spent 50 years or more trying to get people to stop smoking cigarettes, right? Mm-hmm. Yeah. And they were pretty successful at doing that. When you look at the statistics of how many people actually smoke cigarettes, I remember growing up in the 80s and everybody smoked, People smoked indoors, people smoked in offices, and everybody smoked. And nowadays, I live in California, so it's probably more skewed than anywhere else, but you can't smoke anywhere. I don't see anybody smoking. And, you look at the statistics, I think they say 2% of America smoke cigarettes now, which is negligible. That's pretty much nobody smokes cigarettes. So obviously, the people that still do smoke cigarettes, business and enterprise are always going to come up with an alternative. So they came up with the e-cigarette. And so the e-cigarette was designed as a mechanism to help wean adults who are otherwise addicted to cigarettes, to try to help them stop smoking cigarettes and smoke something that would be a better alternative for them. Now, like any business, e-cigarette companies, they want to advertise and market their products and make it look cool. So think the Marlboro Man. I used to always think when I would drive by a billboard, look at that cowboy. He looks really cool with that cigarette in his mouth. And that attracted a lot of people to want to smoke cigarettes. So e-cigarette companies obviously came up with creative ways to advertise and market their e-cigarette products. Now, that's all well and good, and the FDA probably wouldn't have cared if their marketing was being successful with adults. The problem is e-cigarettes became cool amongst younger demographics, in particular teenagers. And so what you saw is a spike in teens using e-cigarettes. So it was one of those situations. The reason why I said whack-a-mole was because you whacked one problem and were able to successfully pretty much negate that problem. And then another problem popped up over on the right, which is teenagers are now really into e-cigarettes.
And explain the issue in the case the Supreme Court heard this week.
So the issue that you currently have before the Supreme Court, it's more of what is the authority of the FDA. That's the actual legal question the Supreme Court is looking at. But I will say that one of the balancing tests that the Supreme Court is having to deal with is, well, okay, I understand that the FDA is trying to regulate, the advertising and marketing of cigarettes to teens. But the question becomes, well, one, do they have the authority to do that? And whether or not they have the authority to do that is more of a gray question, because I think the Supreme Court is looking at it as, well, what they're doing is coming from a good place. They're trying to protect the health of the future generation. And so I think that's the particular issue that the Supreme Court is grappling with right now, which is why when you listen to the oral argument, even, everybody said, oh, it's a conservative court. They're probably going to side with big business. They're going to side with the e-cigarette companies. And what you heard in oral argument is it sounded like the Supreme Court was kind of deferring to the regulatory authority of the FDA.
Yeah, that was surprising. Justice Kagan said, I guess I'm not really seeing what the surprise is here or what the change is here, because basically everyone knew the FDA's position on e-cigarettes. So the question that Brett Kavanaugh brought up is, well, what's the relief here, even if you win e-cigarette companies?
Exactly. And that's the big question. And that's usually the biggest problem. It's funny. Everybody spends all their time in law school thinking about the big legal arguments of why I'm right on a particular issue, but nobody ever thinks, okay, well, what if I win? What's the remedy? Which is why when I talk to young law students, I always tell them probably the most important class you will take while you're in law school is remedies. And they look at me confused, like, remedies? Like, what are you talking about? That's like what happens after the case is over. And it's like, yeah, I know, but think about it. You can spend $10 million arguing that you're right, and then the court says you're right, and then they ask you, well, what do you want? And so that's the issue here is, for e-cigarette companies, it's like, okay, well, even if you are correct in saying that the laws that the FDA is imposing here are arbitrary and capricious, which is the core legal argument that the e-cigarette companies are making, which is a good legal argument. They're basically saying you're making up rules and regulations that are effectively a moving target. So me as a company, I can't even craft policy to address your concerns because every month you're moving the goalpost on me. And so the Supreme Court has effectively said, okay, let's say that we do tell the FDA that they need to be more definitive with their rulemaking and say, these are the laws and regulations that govern the advertising and marketing and the regulation of e-cigarettes. How does that help you?
Are the e-cigarette companies just looking for more time to start the process over again, or do they not want to start the process over again?
I think timing is definitely of concern, because if you think about it right now, one of the biggest things, and nobody really talks about it when it comes to businesses and advertising and marketing, but they currently have the attention of a generation. So they have captivated a particular generation. So when you look at cigarette companies effectively capture the imagination of the baby boomers. And that's a very large demographic. So if you're selling a product and you have a captive audience and a whole generation of, so for e-cigarette companies, I guess you would call it Gen Z. The other day I heard that apparently there's a Gen A now.
I've lost track of the gens, so...
Gen Z, I believe, is effectively 16-year-olds to young professionals. So let's go 16 to 30. Right now, that is the demographic that is very captivated by e-cigarettes. And I think the sense of urgency from the e-cigarette generation right now is that they are now being prohibited from advertising and marketing to Gen Z, which could be a very lucrative demographic. Because the thing about especially products like this, if you develop brand loyalty right now, This is the type of product that they will use throughout their lives. It's not like a toy or a video game where a person may grow out of it or phase out of it. You know, if you're an e-cigarette person, you may be using e-cigarettes for the next 30, 40, 50 years.
Do vaping companies have problems getting regular e-cigarettes approved, or is it just about the flavored e-cigarettes?
For this particular case, and that's a very important question. For this particular case, you're talking about the flavored e-cigarette, because that's what the FDA is saying. They're saying the e-cigarette companies with the flavored cigarettes, you're no longer targeting the 40-year-old who is trying to wean themselves off of cigarettes. You were targeting the 13, 14, 15-year-old to try to entice them and to hook them on e-cigarettes so that you have them for a generation, so that you have them for the next 40, 50 years. Now, e-cigarette companies would probably deny that, but that's absolutely what they're trying to do. And I'm not saying that there's anything wrong with it. That's smart marketing and business strategy. The focus of this particular case that's before the Supreme Court is the flavored e-cigarettes. And the reason why it's the focus of the court is because the FDA is arguing you are advertising and marketing these flavored cigarettes in a manner whereby you are trying to make them incredibly attractive to Gen Z, 13, 14, 15, 16, 17, 18-year-olds. And by doing that, you are compromising their health now and for future generations. E-cigarette companies are arguing, well, you can't create an arbitrary and capricious rule that says you as an e-cigarette company can advertise and market your e-cigarettes. You just can't do it in this manner. You can't have flavors.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Shawn Collins, how the president-elect's name came up in the oral arguments over flavored e-cigarettes. This is Bloomberg. Supreme Court justices seem skeptical that they could give any relief to companies whose applications to sell flavored e-cigarettes were denied by the Food and Drug Administration. Several of the justices pointed out that even if the companies reapplied, the FDA would continue to deny the applications. Perhaps the vaping company's best hope is the incoming Trump administration. Here's the attorney for the vaping companies, Eric Heyer.
And frankly, we don't know how FDA is going to approach it on remand. We have a new administration coming in. The president-elect is on record saying, I'm going to save flavored vapes. We don't know exactly what that's going to look like. It may be that the approach the agency takes is much more aligned with the statute and looks at all the risks and benefits.
I've been talking to Shawn Collins, a partner at Strading. So this is an appeal from the ultra-conservative Fifth Circuit. There is a circuit split. The 2nd, 3rd, 4th, 5th, 6th, 7th, 9th, 10th, and D.C. circuits have sided with the FDA and denied the petitions or requests to stay the agency's marketing denial orders for flavored e-cigarettes. So the Supreme Court almost had to take this case to straighten it out, even though more than one of the justices said there was no real relief to be had here.
That sounds like what's happening here. I was surprised that the Fifth Circuit was the lone wolf here, for lack of a better word. You know, it's not the type of ruling that I would have expected out of the Fifth Circuit. But, yeah, no, I mean, that's what the Supreme Court is up against right now, is effectively overruling the Fifth Circuit.
Is it surprising that the justices seem to be crediting the FDA's expertise here? I mean, this is a court that has been skeptical of the power of federal regulators, including by striking down the Chevron doctrine that had judges deferring to agencies' interpretations of the law.
I personally don't think this is kind of outside of what's to be expected from this particular court. I think that this court is very fixated on not necessarily tearing down the authority of a particular agency, but making sure, especially with this particular Supreme Court, they are very focused on making sure that a particular agency does not exceed the authority that was originally granted to it. And so, for instance, I'll use the FTC as an example. Obviously, we're talking about the FDA with this particular case. But, it was probably, I think it was 3 or 4 years ago now, there was a ruling that effectively said, hey, the FTC has gone way beyond the bounds of what the authority that was originally given to them by Congress. You know, it's a bit, in the military, we call it mission creep. Mm-hmm. Meaning you set out for objective A, and then the next thing you know, you're going after B, C, D, E, and F. And it's like, before you know it, everybody starts asking the question of, all right, well, when did the FTC get into the business of going after these types of cases? And so with this particular issue, I think the Supreme Court is looking at it and saying, again, this is kind of how I started my comments, was, well, at a very high level, why did we create the FDA? Well, the FDA was created because back in the 1800s, there was a severe problem with the quality of food, and there were effectively snake oil salesmen out there selling drugs that were doing serious harm to people. And so as a society, we decided we should probably have an agency that's responsible for regulating the food and the drugs that are sold and marketed in the United States of America. And when you cut through the red tape of that, what does that mean? How do we keep Americans safe? And so when you look at what the FDA is doing here, they're saying we are creating these rules because we are trying to keep teenagers safe. You know, we have 80 years worth of literature and research that pretty convincingly prove that smoking is bad for you. It's really bad for your lungs. It causes lung cancer. And I don't think there's anybody that disagrees with that. And e-cigarettes, while they are a better alternative, they're still not great for your health. And the FDA has presented some pretty convincing evidence, again, that kind of goes beyond whatever your political views may be. And it's kind of unequivocal that e-cigarettes are probably not good for the lungs of teenagers. And so the Supreme Court is looking at this and saying, well, the FDA has been tasked with keeping teenagers safe, and they are now passing laws and regulations that are very focused on keeping teenagers safe. Kind of straightforward, you know. Even in this concern, the Supreme Court has to look at it and say, good job, FDA, you're doing your job.
During his campaign, Trump said that he was going to save vaping, basically. And during the oral arguments, the attorney for the companies pointed to that. So what's the effect of a new administration? Can the FDA just do a 180 on e-flavored cigarettes?
Obviously, whenever there's a new administration, there's always, every federal agency, there's going to be a significant shift in policy. So whoever takes over the FDA is going to be a Donald Trump appointee, and they are going to execute the wishes of President Trump. Now, I will say that when President Trump says, you know, I'm going to support e-cigarettes, he can do that and still kind of adhere to what the Supreme Court is talking about here. Because keep in mind, think about, who did he appoint as his head of Department of Health and Human Services? RFK Jr. And they've already talked about saying, all right, we're going to, you know, use a lot of scrutiny with respect to the drugs that we are administering to the American public. So when you look at what's going on here, and let me say this, because I want to be clear, I am by no means beating up on the e-cigarette industry at all. What's at stake here is the fact that the FDA believes that the e-cigarette company are advertising and marketing their products to people who are not legally authorized to buy their products. I probably should have started with that. And so what the FDA is saying here is, hey, e-cigarette companies, if you want to put billboards up on every single billboard along every major freeway in the United States to say, if you are 18 and up, you should really buy my product, knock yourself out. But the problem is the data suggests that the flavored products that you are marketing, more 14, 15, and 16-year-olds are buying your product than 18 and up. And we think that is very intentional on your part, and that you are aware of the fact that your advertising and marketing is targeting and being more effective with people who are not even legally authorized to buy your product. That's what they're taking issue with. And I think that, candidly, when you look at who President Trump picked for his Department of Health and Human Services, RFK Jr., and then his other mandate of I will support e-cigarette companies, I think he can achieve both of those objectives. He's effectively saying, hey, e-cigarette companies, if you want to increase your profits and sales to 18 and up, so be it. As long as you don't break any laws, go for it. But you can't market your products to 13, 14, and 15-year-olds.
Thanks so much, Shawn. That's Shawn Collins, a partner at Strading Yocca Carlson Rauth. And for those who are counting on President-elect Trump to change the rules for flavored e-cigarettes, let's take a look at his various positions during his first administration. In 2019, Trump threatened to ban most flavored e-cigarettes from the market due to concerns over the appeal to children. He later backed off the ban after it was met with industry resistance. In 2020, his ban on certain e-cigarette pods made by companies like Juul Labs prohibited flavored e-liquids but allowed menthol and tobacco products on the market. He also signed a law that raised the federal legal age for purchasing tobacco from 18 to 21, which vaping proponents say lowered youth vaping numbers. So stay tuned. Coming up next on the Bloomberg Law Show, the justices once again faced a question over the role that U.S. courts should play in returning property stolen from Holocaust survivors by foreign countries during World War II. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court once again struggled with the role that U.S. courts should play in returning property stolen by foreign countries during World War II to its original owners. In several cases brought by Holocaust survivors against foreign nations, the justices have wrestled with how to balance the international friction that can result from hauling sovereign nations into U.S. courts, while at the same time fulfilling Congress's intent to allow suits in some cases. In a case the justices heard on Tuesday, Holocaust survivors and their families say Hungary and its national railroad stole property from Jews while transporting them to concentration camps. The question is whether the U.S. is the proper place to resolve the legal dispute. Joining me is MC Sungaila, a partner at Complex Appellate Litigation Group. So, MC, we have seen similar cases before. In fact, we've seen this case at the Supreme Court before.
You know, this isn't an art case. This is really all kinds of property case. Most of these cases are involving some kind of Holocaust art recovery. But this is, yes, we sent the people off to the camps, and we also took, all of their property and transported that on the rail line. So they've been trying to, make this claim and have been really, like many of these Holocaust claims, really bouncing back and forth between the Supreme Court, the Federal Court of Appeal, the District Court on some, very threshold issues, which often come up in these cases involving sovereign immunity. Under the Foreign Sovereign Immunity Act, can you sue the Hungarian government or some other country's government for these activities?
We've talked about this so many times. I'm surprised this issue isn't more settled.
Yeah, I was just looking back at some of the sovereign immunity questions that have come up in the Holocaust context, and really one of the last, ultimately successful ones was Altman back in 2004, where the question there was just whether the Foreign Sovereign Immunities Act applied retroactively or not, and therefore allowed Maria Altman to bring her claim against Austria for her paintings that Austria had taken. And in that case, the court said, yes, the Foreign Sovereign Immunities Act applies retroactively, and therefore property taken in violation of international law, which her case qualified for. Yes, okay, that's the standard, and you can sue governments for that. But since then, it's been this case and others have really dealt with, okay, now that we know that it applies retroactively, what are the sort of exceptions within that statute that allow these kinds of claims to be brought, and how do all of those various exceptions, kind of work out and end up applying? And so here, this expropriation exception, and really it seems like the D.C. Circuit has been trying very hard to find a way to allow these claims to be brought, right? It's all various aspects of expropriation that they've been hanging their hat on to say, no, you really need to look at this more carefully, district court, or there's a possibility here, that a claim could be brought. We need to look at that again. And each time it's been sent back on the particular theory that the circuit may have relied on, but the Supreme Court has even opened up other avenues for consideration. And so that's why it keeps coming back, is you think we haven't solved these problems already. We haven't figured out the scope of sovereign immunity. And it seems like here is this effort to make sure we have turned over every rock, to make sure that we have fully investigated every potential for a claim against Hungary. It keeps coming back for that reason.
The cases we've discussed before involved artworks, particular artworks that were stolen. This case involves property, and it's unclear to me what kind of property that the Hungarian government stole and then liquidated, and the money went into the national treasury. And then that fund was used to issue bonds in the U.S. But how would they trace the stolen property to the bonds?
Well, that's the question, and I think that was the concern that really animated oral argument, really on both sides. Some of the justices suggested, well, this question of commingling and the proof of commingling and what percentage of the money here in the U.S. Needs to be either theoretically or potentially traceable to this nationalized property that had been taken from Jewish families. And that was really kind of the rub, right, of the petition asked what level of proof and who needs to prove it. And the justices were kind of scratching their heads saying, well, on the one hand, we're concerned that you as a claimant could almost make any claim, right? Sure, there must be some trace element of commingling, or there could be, and as a result of there could be even a small amount, that now you can make a claim against another country in U.S. courts. That seemed concerning because this is an exception to the Sovereign Immunity Act, the general provision saying you cannot sue countries in U.S. courts. And on the other hand, there were the concerns raised, well, if you don't have allow some kind of claims for commingling and giving some kind of laxity for that definition, then any bad actor could just go, oh, well, I'm going to take this property, and then the next thing I'm going to do is I'm going to commingle it with something. I'm going to put it somewhere else, and then that will immunize me from this exception to have claims brought against me. And so there's also that concern that, well, if you make it too easy for someone to kind of hide the ball and get themselves outside of this exception, then what's the point of having the exception? So both of those concerns about going too far and concerns about, letting folks who are violating international law off the hook more easily. Those were the tensions that the members of the court identified.
I feel like I've heard the same concerns from the justices about, the risk of reciprocal actions by other countries. Yes. And it's a big deal to haul a foreign country into U.S. court. I mean, those are the same things they've been saying for years.
Yeah, exactly. It's the same. It's the same because it's the same concerns and policies animating U.S. foreign policy and the, State Department's view on these things. And also they're looking at the Foreign Sovereign Immunity Act and the various things that Congress stated in enacting those. So yes, they come up with the same concerns because they're looking at various aspects of the same statute. And so the same policy concerns.
Could you tell at all from the oral arguments which way it was going? It seemed to me like the justices were all over the place.
I think it's hard. I think it's harder to tell here, but if you look at their overarching concerns that you mentioned before, which is we don't want to open the door to everyone to bring their concerns to U.S. courts, and maybe somebody could do this to us, and we want to be careful about that too, being hauled into other courts, that is the general, conservative sort of reaction to this is to say we don't want to do anything that would make that easier. We want to be very cautious about that. And so you'd say, oh, well, if you want to go with where the court ends up going normally or typically in these cases, they typically end up being, very narrowly construing the exception to the Foreign Sovereign Immunity Act. But on the other hand, every once in a while you have a case like Altman where they said, okay, we're opening this up, we're applying the act retroactively and, allowing this claim to be brought. So it's possible, but those concerns are still animating the court. And so it's possible, but most likely that they will close the door to this one too.
And the Altman court, I don't know what justices were on the court at that point, but most of them are certainly not on the court now.
It's a completely different court. I mean, that's 2004. So we're talking, 20 years ago. It
doesn't seem like they're split ideologically.
No, that's a good point, June. You can't say, oh, well, the conservatives are this way and the more liberal folks appear to lean another way on these issues. It's really this larger concern about their role, the court's role, the executive branch's role in sovereign immunity. So it's not an ideological question, but it is a question that across, multiple iterations of the court that they've had this concern. They want to make sure that they are executing on what Congress has legislated and that they're not going any further than that.
It seems like they might have taken the case to reverse the D.C. Circuit. Is that your conclusion that they're going to end up reversing the D.C. Circuit in some way, through some argument?
Yeah, it's possible, although in the past they've opened up, they've closed one door and opened another one for this case, which is why it keeps coming back too. So, perhaps that will happen again, that one door gets closed, another door is, at least slightly ajar, and then the case continues, because the D.C. Circuit at least seems very interested in making sure that they have explored every potential avenue before they say absolutely you should not be bringing your claims here.
And before I let you go, tell me about your big win yesterday at the Ninth Circuit.
So my case yesterday was another long-running piece of litigation for the city of Costa Mesa, and I've worked on various appeals for them involving challenges to their sober living home ordinances. So they allow sober living homes in their city, but they have certain permitting requirements for them that are, requiring certain distances. So in other words, you can't have a residential street with, multiple of these homes or sober living homes on them, because that would be a bad thing, not only for the residential environment, but for the residents who are there, who are trying to be integrated back into traditional living arrangements after they've been in recovery. So this has been challenged as, violating various federal and state fair housing laws and harming the disabled. And today, or yesterday, the Ninth Circuit agreed with the city of Costa Mesa that there was no discrimination of various, whether it's facially discriminatory, whether it's a disparate treatment. There was no discrimination, and in fact, these ordinances were designed to benefit the disabled residents of these homes. It's a really wonderful result for a city that has been standing up, for its ordinances for many years, and helpful to other cities and counties and local governments who want to have similar kind of land use regulations that help all of their sort of balance the interests of all of their residents, including those who live in these homes.
It's great to talk to you, as always, MC. That's MC Sungaila, a partner at Complex Appellate Litigation Group.
And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. I'm June Grasso, and you're listening to Bloomberg.